Are you afraid of that or
A little anxious, sir, but not much.
anxiety is there? It is Sunday. Alright, Haramrit, what is the aim of Order 38 of CPC?
So, sir, Order 38 of CPC, the aim is basically that at the end of the suit, if a decree is passed, then the decree holder should be made available the fruits of the decree. So, the proceedings are taken before the decree.
It is 38.
The
38
arrest.
is telling something else. It is talking about before judgment,
Yes.
before decree. Decree has not yet been passed. Judgment has not yet been passed. I hope you will be able to give the right answer.
So it is basically that if the defendant, he is trying to avoid the proceedings of the court in order to defeat or destroy either the proceedings or the ultimate execution of it, then before even the decree is passed, the court either allows the arrest or to give security for his presence in the proceedings or will allow the attachment of the property.
Alright. Can you elaborate in which circumstances the property can be attached?
So, sir, the property can be attached if in order to delay or obstruct the proceedings of the court, he is either about to dispose of or he is about to alienate the property which is within the jurisdiction of the court, then in such cases the court can order the attachment of that property.
Alright. There is one chapter in Indian Evidence Act which is showing that facts which need not be proved. Can you elaborate that?
Yes, sir.
Which is the chapter?
Sir, I do not recollect the chapter number, but there are two provisions in that. First is the facts of which judicial notice can be taken, they need not be proved. And secondly, the admissions which are there, they also need not be proved.
Can you tell us what the doctrine of relation back is?
So, sir, the doctrine of relation back has been in the ancient Hindu law, which basically provides that if a child was adopted subsequent to the death of the husband, then such child would be adopted by the widow in the rights of her husband and not in her individual rights. And when a child is adopted, his adoption or his birth will be taken as from the date of the death of the father and not subsequently. So it is basically to ensure that he gets a right in the property of the father from the date of the death of the father.
Some provisions of Registration Act is also dealing with this. What are those provisions?
So the provision which deals with adoption is that is when you give the authority to adopt a son, they are required to be compulsorily registered, and if they are not registered, then they will not be deemed to bestow any authority on the parent.
Whether criminal and civil case on same facts can continue simultaneously?
Ma'am, because civil and criminal proceedings, they are two separate proceedings. The parties in both the proceedings are separate. The issues which are required to be proved are separate. So there is no bar that simultaneous proceedings cannot be continued in civil as well as criminal proceedings.
Can you give some examples where both the cases can simultaneously?
Yes, sir. So if we talk about the case of defamation, then the defamation is a tort as well as a criminal wrong under section 499 IPC. So one, you can institute a criminal proceeding. Along with that, the proceedings for compensation for defamation can also be continued.
Alright.
Is police encounter a proper process under criminal law?
So when we talk about police encounters, though there has been provision that when you have to make the arrest and the person avoids the arrest, in such cases you can use necessary means to effect the arrest of the person. But at the same time, no killing of that person will be done except where the offence is punishable with death or imprisonment for life. So it is only in such cases that the police can, in retaliation or where the person is avoiding arrest, can use force, but otherwise it is not constitutional by law.
Can you quote the section of CRPC which talks about the same?
Sir, if I can correctly remember, it is section 46 of CRPC which deals with arrest how made.
Alright, With regard to Order 70, what is contained in Order 70, how it can be made effective by the judge for the purpose of expediting the disposal of civil suits?
So, sir, Order 17 basically provides for adjournments in CPC. Now, in order to avoid the unnecessary delay in the process of the proceeding, it is provided that we will allow a maximum of 3 adjournments. Even though this is a shall provision, but in the case of Salem Advocate Bar Association, it was held only in exceptional circumstances more than 3 adjournments can be granted. So it is the responsibility of the judge that no unnecessary adjournments are granted. Also, we have to have the proceedings from day to day until all the witnesses who are present, their examination is done. And in case any party is trying to delay the process, then they can proceed under the provisions of Order 9. That is, either you can dismiss the suit or you can proceed ex parte.
There are 2 terms, transportation and transposition. What are their respective meanings?
Transportation with respect to CRPC would mean that there is a provision which provides for earlier, if we talk about pre-constitutional laws, then there was transportation of life as a means of punishment, but now it has been eradicated by the provisions. If we talk about transposition, it relates to the parties and is the arena of civil law. Example, there was a defendant. If in such cases the defendant is made a plaintiff, or in some cases the plaintiff is made the defendant, then such cases are said to be the transposition of parties.
Alright. There is one chapter in CRPC, submission of death sentence for confirmation. What is that chapter?
So when we talk about a death sentence, the Court of Session does have the power to pass a sentence of death, but the death sentence will not be executed until and unless it is confirmed by the High Court. So this particular chapter deals with the proceeding where the Court of Session has given the sentence of death, then you will submit it to the High Court for its confirmation, because only after that it can be executed.
Can you refer to the section also? And these are the sections which are given.
So the sections which deal with it are Section 366, which provides for the submission, Section 368, which gives the order of the High Court for its confirmation, or any other order.
So,
Can you throw some light on a decree passed in contravention of Section 10 of CPC?
Yes, sir. So decree passed in contravention of Section 10 of CPC, it can be said to be a mere irregular decree and not a void decree. The decree is executable by the court unless a party takes an objection to such decree, and if the court feels that the prejudice has been caused, it sets aside the decree. Otherwise, it is an equally good valid decree for the purposes of execution.
what type of prejudice can be caused? Can you narrate that?
Sir,
Because there were 2 suits, one was earlier filed, one was filed later on. No, the suit which was filed later on, it has been decided. What type of prejudice has been caused?
so the prejudice is that one person is being vexed twice for the same cause, and in such cases there is always a risk
No,
of
but earlier suit will be hit now by Section 11.
Yes, sir.
Still some prejudice will be caused.
Sir, I'm not very sure.
No, there is no prejudice can be caused. Simply we can say that earlier suit will be hit by the doctrine of publicity, but
Why affidavit is not included in evidence?
Ma'am, to my limited knowledge, affidavit is not included in the evidence because it is the basic requirement of the essence of the natural justice that a accused, all the proceedings must be in the presence of the accused person, and the evidences should also be taken so as to allow him a fair trial. In affidavit, it is only a document that is presented before the court, so the Evidence Act will not apply. But yes, if that person appears before the court and he affirms the statement made, then because now it is made in the presence of the accused person or his pleader, it would be taken as evidence.
Yes, Sanjay.
Can more than one FIR be registered with regard to same offence?
There has been multiple cases, sir, where more than one FIR was registered. A very famous is the Nupur case, where she made certain statements against Prophet Muhammad. So wherever the statement was published, every person has a right to put an FIR, though the Supreme Court has warned against it, that it is the abusive process of the court, so it should not be, it should be avoided, but otherwise there is no restriction in putting up of more FIR than one.
No, under which section FIR was registered in that case?
Sir, I do not remember the section, but it is where there is the section which deals with cheating by by letters or otherwise. That is where the publication is also implied in that.
Sanjay, you wanted to continue?
Will it be hit by any article of Constitution if more than one FIR is being registered with regard to same offence?
Double jeopardy becomes. Yes, you.
What is marshalling?
Sorry?
Marshalling. What is marshalling?
Okay. Ma'am, the concept of marshalling is basically if in mortgage, it is a concept of mortgage as well as sale. So if we'll take an example that X has property A and B, and he has given both these properties mortgaged with C. Subsequently, he also mortgages property B with D. In such cases, D can have an arrangement that the prior mortgagee, he can satisfy the debt from the property which has not been mortgaged to him so as to protect his interest, but the concept is of marshalling would only be applicable where it does not prejudice the rights of the prior mortgagee as well.
Alright, there is a procedure for trying criminal cases by the court of session. Can you narrate which is the chapter in CRPC?
Sir, if I'm not wrong, it is chapter 18 of CRPC.
Exactly. So, how the session will proceed? What is the procedure?
So the procedure for court of session is the case will be started by the public prosecutor, who is set to open the case, where he will define the case, the facts of the case, and also the evidences which will he prove the case with. Subsequently, if the court of session is satisfied that there is no case made out, or if the charges are groundless, he has the option to discharge the accused person even before the framing of the charges. If the opinion is not such, then the charges will be framed, the prosecution and the defense evidences will be taken, the arguments will be done, and then the court will pass a judgment on it.
Yes, sir.
With respect to Hindus and Muslims, can you tell us what is a gift whether a gift of future property is valid or not?
So if we talk about Hindu laws, the gift of future property, I do not exactly remember it, but to my limited knowledge, it is not valid, because gift, if we talk about the provisions of Transfer of Property Act, it is the property must be in existence, and because to Hindus Transfer of Property Act applies, so gift of future property will not be valid. But if we talk about Muslim law, the gift of future property to some extent can be said to be valid if the property comes into existence at the date of the death of the person, if I'm not wrong, like it has before the death of the person.
Alright. With regard to mortgages, which are the mortgages which fall under Order 34?
So there are three mortgages, which are the law with mortgages is the whenever a suit has to be instituted with regard to any mortgage, all the mortgagees must be made a party to the suit, except it is said that when a subsequent mortgagee puts up a suit, then the prior mortgagee need not be made a party when the suit is for redemption or when the suit is for foreclosure or sale of the property.
Which are the kinds of mortgages?
Okay, kinds of mortgages. Sir, I'm not very sure about it.
Any one or two or three?
Okay, only the kinds. So there are 5 kinds of mortgages: simple mortgage, conditional mortgage, English mortgage, usufructory mortgage, mortgage by title deeds, and then there is anomalous mortgage.
Can you narrate some example with regard to anomalous mortgage?
So anomalous mortgage can be said to be example where a person, he gives the property, he transfers the possession of the property to the mortgagee, and in such cases also puts up a date up to which you can hold the property, on the expiry of which he will take back the property on the payment and personally binds himself. So it can be said to be the anomalous mortgage in terms of simple as well as usufructory mortgage.
Yes, you.
What is premature discovery?
Ma'am, in the chapter of discoveries, when the court is satisfied that a particular document is not required at the particular stage of the proceedings, it might be required only at a subsequent stage, so the court can refuse such discoveries on the ground that it is premature at the particular stage of the suit.
Yes, Sanjay.
What are the rights of unpaid seller under Sale of Goods Act?
Sale of Goods Act, there are 3 rights which are available to an unpaid seller. The first right is you have the right of lien of the property. It is only up to when you have the possession of the property. When you have given up the possession of the property and the property is in transit, then you have the right to have the, I do not exactly recollect the name, but it is you can recall the goods from transit and retain the possession. The last right is the right of resale. And where the property and the goods have not transferred, then also the unpaid seller has a right that he can stop the delivery of the goods to the buyer.
Yes, Sanjay. Please see. Yes, Haram. In CRPC there is one chapter. Securely between the peace and good. Can you read?
Sir, it is chapter 8 of CRPC which deals with security for keeping peace and good behavior. In this chapter, majorly except section 106, the powers are with the executive magistrate, which are merely...
Under 106.
No, except 106. 107, 108, 109, 110. The powers are with the executive magistrate, and these are merely preventing powers. That where he has an apprehension that public peace may be disturbed, or there is an habitual offender, or a person is trying to conceal his presence, then you can show cause a notice to such person to ask him why he should not be asked to execute a bond for peace or good behavior.
What is 106?
So 106 is the power of judicial magistrate, that is either the court of session or the judicial magistrate first class. At the time of conviction in certain offences, they can require the person to execute a bond for keeping good behavior after the execution, after the sentence has been completed.
No, it is in place of sentence.
No, sir. It is after the sentence has been, he has fulfilled
It
the
is in
sentence.
addition to sentence.
Yes, sir.
Alright. Perfect.
Can you tell me how the evidence is to be recorded under Order 18, Rule 4 of the CPC?
Ma'am, when we talk about Order 18, Rule 4, it basically provides that the examination in chief, it has to be done by affidavit. The cross-examination and re-examination can either be done by the court or it can also be done by the commissioners at the request of the court.
Son.
Can you tell us what is your take on the role of technology in the legal system?
Sir, because now world has become a global village, everybody is connected with just one swipe finger. So I think that the technology has brought a very substantial change, and it will in coming years bring that. For that matter, we can also see the new codes that are being introduced, where the role of technology has skyrocketed. Now it has become, because the trials have been allowed using video conferencing, the presence of the witnesses and even the accused in certain cases have been allowed to be done by the video conferencing. It has made possible for every person, no matter how far they are from Delhi, to, like if the case is pending in Supreme Court, then they can become a part and parcel of it, even though they might not be an interested party to it. For example, the case regarding the same-sex marriage, it was live streamed. So now it becomes part and parcel of every person's life who is not even concerned with that matter. So I think this has made the role of common man in the legal system a very substantial role.
Alright. Now all criminal laws are going to be amended. What is your opinion? You might have gone through some amendments. What is your opinion whether the amendment will be a right one or it will create a chaos in the society?
Sir, in my humble opinion, opinion, I have had the opportunity to go through these laws, and an observation that I have made is that I do not believe there has been any substantial change introduced in these three acts. The reason being, they have only shuffled the sections and the chapters, which is going to cause a lot of inconvenience, not only to the legal fraternity, but I believe to even the common man who earlier used to know what is section 302, what is section 307. Now they will have to become accustomed to it. In addition to that, because the prior proceedings will be continued according to the Indian Penal Code, IPC, CRPC, but the new cases will be done according to the new acts, this is going to be very chaotic in the legal rooms, in the courtrooms as well. So I believe that if they wanted to bring changes, these changes could have been easily brought even by amendments. So there was no need to shuffle the entire law just for the matter of convenience.
Otherwise, there should be training for judges also,
Exactly.
for advocates also,
Yes.
to learn the sections which are the sections, because we are not knowing all those sections which are newly created. Every section is changed. Yes, sir, please.
Can you tell me, whenever civil judge pass any decree or any judgment, and after that, can it amend that decree or judgment after pronouncement of that judgment? And if it is yes, then under which provisions of the CPC?
Ma'am, if we talk about once the judgment is pronounced, it becomes final. But there are in CPC few exceptions. The one is to correct any arithmetical or any clerical mistake or even an accidental slip. The other one is by virtue of review. When the judges review their own judgments, then they can always alter their judgment.
And under which provisions they can amend?
Ma'am, the law regarding the arithmetical or the clerical mistakes, it is section 152 CRPC, CPC.
Yes, one.
State something about development with regard to section 124A of IPC.
Ma'am, section 124A of IPC basically deals with the law of sedition. But recently, the Supreme Court in the case of S.G. Mohammed Khere versus Union of India, it has put the section 124 in an eclipse position, whereby no new FIRs and no proceedings will be continued under this section until the central government revives it. But a recent change which has been introduced is that now the Supreme Court has referred the case to a 7-judge bench so as to review the judgment which was passed by the Kedarnath bench.
Yes, sir. There are some offences related to false evidence, which are where it is mentioned in the IPC.
Sir, in IPC we have section 200 and 201 which deals with false evidence and fabricating.
200 and 201 IPC.
ਹਾਂਜੀ sir.
Something else.
Sir, 202 gives the punishment for it.
IPC. IPC, there is a separate chapter which is dealing with the false evidence and offences against public justice.
Sir, I'm sorry, I
Chapter
cannot recollect.
191, 192.
Yes, sir, I'm sorry,
193.
I misinterpreted that.
You are going to CRPC, I think.
Yes.
Alright. Can you explain?
Yes, sir.
What
Sir,
is false evidence?
हाँ जी sir. So false evidence is where a person who is bound by an oath or otherwise he is bound by any law to make a declaration or to state the facts, he states a fact or makes a statement which is false and which he knows or has reason to believe to be false or does not believe it to be true. That is giving a false evidence. And 192 deals with fabricating false evidence, where you make any document, any entry or any statement with the intent that it will be used in a judicial proceeding and it will be relied upon by the authority to pass a judgment or base its decision, and which you know to be false, then that is said to be fabricating false evidence.
It is punishable under section 193.
Yes.
Can you tell us what is the punishment under 193?
Sir, I do not recollect the
Seven.
punishment. Seven.
Punishment is 7 years. What are the offences of affray?
So the offense of affray is when two or more persons they fight in a public place and they cause public disturbance is said to be the offense of affray, which is punishable under section 160 IPC.
Can you tell us what is laid down in section 165 of Evidence Act?
So Section 165 of Evidence Act is the unbridled power of the court, where it provides that the court may, at any stage of the proceeding, in any form, from either a party or a witness, it may ask any question which could be relevant or irrelevant, and may also call for the production of any document or any material thing in order to have the better appreciation of evidences or as an aid to the entire procedure.
And the judge,
Can you tell the exceptions also that the court cannot ask these questions?
Yes, sir. So the privileged communication that is available to the parties, the judge cannot ask such questions. Also, the judge is restricted from asking questions which have been prohibited under section 148 and 149 of the Indian Evidence Act. And also it is that you cannot take secondary evidence in your discretion except where it has been provided by the provisions of Indian Evidence Act.
Yes, what is this stopper and where it has been provided? Give one example also.
Yes. So the law of estoppel is basically that where a person makes a representation to another by an act, omission, or by an act or a declaration, and intentionally induces that person to act upon it, subsequently the person cannot be allowed to deny it. Now, sir, the principle of estoppel has been provided in different laws, which are as follows: Indian Evidence Act, Transfer of Property Act, Indian Partnership Act, and Indian Contract Act provides the law of estoppel. One example of it could be where A, he made a representation to B that X belongs to him, and he makes an arrangement to transfer that property. But actually that property was A's father's property who is about to die. Subsequently, now if his father dies and he gets an interest in the property, he would be bound by his estoppel and he will have to make good the contract between the parties.
What is conclusive proof?
Ma'am, conclusive proof has been provided under the Indian Evidence Act, where one fact is said to be the conclusive proof of another. On the proof of such fact, now the court is going to deem the other fact as proof and no evidence to rebut it will be allowed. A very prominent example of it is the legitimacy of a child, which has been provided under section 112 of the Indian Evidence Act.
Any more sections which are dealing with conclusive proof
Yes,
of
sir.
Indian Evidence Act?
Yes, sir. There is section 41 as well as section 113, which deals with the conclusive proofs.
You just mentioned the doctrine of relation back with regard to adoption. The doctrine is also applicable with respect to CPC. Can you tell which provision deals with it?
Ma'am, I cannot recollect it as of now. I'll read upon
No,
it.
explain.
Okay. If we talk about doctrine of relation back with respect to CPC, it applies when a party is substituted under Order 1 Rule 10, or if a party withdraws under Rule 1, a party is substituted. Then that party which has been substituted at that point, it would be said that that party was present from the date when the suit was instituted. That is, it will not be stated that the party was added on the date on which it was added. It would be stated that it was added, it was there from the date of the institution of the suit.
Yes,
That is
it is also contained in the Limitation Act also.
Limitation Act.
We link it with the Limitation Act also. Yes, sir, please.
Can you throw some light on doctrine of pious obligation?
Ma'am, the doctrine of pious obligation has been provided under the ancient Hindu law, which basically is that if a father takes a debt of a that matter grandfather or great grandfather, which was an dharmic debt and not an adharmic debt, then in such cases the obligation is of the child, the grandchild, or the great grandchild to pay that debt, which is only on the grounds of being pious. That is the religious obligation and not from the perspective of the creditor.
Yes, sir. What is Pinda relationship?
Sir, Sapinda relationship has been defined under the Hindu Marriage Act. A Sapinda relationship with regard to one person, it stands in the line of ascent up to 3 degrees from the mother's side and up to 5 degrees in the father's on the father's side, in the counting of degree, the person who is concerned will be taken as the first degree, and it is always followed upwards. So under the Hindu Marriage Act, a person is not allowed to marry another who falls either within the Sapinda relationship or where there are two persons. They cannot marry one another when they have a common ancestor or a common Sapinda in the line of Sapinda relationship.
Right. Under Hindu Marriage Act, which are the marriages which are void?
So under Hindu Marriage Act, we have section 11 which deals with the void marriages. There are three conditions for a marriage to be void. The first one being where it was a bigamous marriage, that is at the time of marriage your spouse is living. Secondly, when you marry with
Where it has been mentioned about bigamy?
So bigamy has been provided under the Indian Penal Code as well as section 17.
In HM.
So section 17 of the Hindu Marriage Act and section 5 of the
Yes.
Hindu Marriage Act.
Section 5. Yes.
What is antecedent debt?
Ma'am, antecedent debt is basically where a person had taken a debt for a particular purpose. Subsequently, he takes a debt in order to repay a debt which is prior in time. That would be said to be antecedent debt.
Yes, Haramrit, there is one order which is dealing with the suits by or against minor. Can you explain something like that?
Yes, sir. So because minor is not a person who is capable in his own power to protect his interest, therefore we have order 32 which deals with the protection of the minor in case of suits by or against a minor. In such cases, if a suit is to be instituted by a minor, it will be done in his name but by the next friend, and if there is a suit against the minor, such cases the court will appoint a guardian ad litem in order to protect the interest of the minor.
So, with respect to Constitution, there has been a lot of controversy with respect to amendment of the Constitution. Can you tell us what is the basic structure of the Constitution?
So the doctrine of basic structure of constitution has been provided in the Keshananda Bharati case. It is basically all those components which form the basic structure of the constitution. They cannot be amended even by exercising the power under Article 368. A few of the things which do fall under the basic structure is, the first is the right of equality, Article 14. Then there is the judicial review. The federalism also falls under this the basic structure doctrine, and then independence of judiciary are some of them.
Parliamentary government is also there. That they cannot come to the presidential government also.
Yes.
Yes, Sachin.
Whether Karta can sell any portion of immovable property out of the ancestral property.
Ma'am, Karta only has the power to sell a part of the ancestral property in three circumstances, which is legal necessity, for the benefit of the estate, or to discharge any pious or religious obligation. Other than that, it can only be done with the consent of the other co-partners.
Yes, Harold, how a suit can be disposed of at the first hearing?
So, sir, we have Order 15 of CPC, which deals with disposal at the first hearing. If the plaintiff and defendant, they appear on the first hearing and the court is satisfied that there is no matter of dispute between them, or suppose the defendant has admitted the case, then the court can proceed to dispose it off. Even if the court considers that there is certain dispute between the parties, but the evidences which are required to dispose of can be put up at the first hearing itself, then the court can proceed to dispose it off at the first hearing.
What are preliminary issues in this CPC?
Sir, the CPC provides for preliminary issues which basically which have regard to the jurisdiction of the court and other such issues which show that on the face of it or prima facie the case would be barred by any law.
Under Hindu Adoption and Maintenance Act, what are the valid conditions for a valid adoption?
Ma'am, there are 5 major conditions for a valid adoption which have been categorized as such. The person must have the right as well as the capacity to adopt a child, which has been dealt under Section 7 and Section 8. Secondly, the person who is giving an adoption must be capable of giving an adoption, which has been provided under Section 9. The child which is being taken in adoption should also be capable as per section 10, and there are other conditions which have been mentioned under section 11.
What are those other conditions?
Ma'am, the other condition, there are 5-6 conditions if I am not wrong. The first one being if a son has to be adopted, then the adoptive parents, they should not have a living and a Hindu son, grandson or great grandson from their predeceased son or predeceased son's sons who is either legitimate or by adoption. Similarly, it follows in case of daughter as well. Thirdly, if there is a male person who wants to adopt a female, or for that matter a female who wants to adopt a male, the age gap must be 21 years and there has to be actual taking and giving of the child, and there can be no simultaneous adoption of the child.
Haramrit, how if Haram files the civil suit, under which provisions they will?
Sir, a firm has been given the right to file a suit under Order 30 of CPC. Whenever a firm files a suit, it can file it in the name of the firm itself, but at the request of the other party, the adverse party, you will have to give the name of the partners who were the partners at the date when the cause of action arose, or such partners who are constituting the firm at the present day to the other party.
Let us come to CPC. How a criminal complaint is tried by the judicial magistrate when it is involving some warrant case?
So, sir, when a complaint comes before the magistrate, which is in a warrant case, the proceedings will be that very first you will have to examine the complainant. After the accused appears or is brought before the court, you will examine the complainants on all the witnesses that are present in the court, and if you are satisfied that no case has been made out against the accused person, you will discharge such person. But if there are grounds for
Discharging or dismissal?
Sir, I believe
It is the initial stage when the court has examined the witnesses, and it is still a stage when the accused is to be summoned or not.
okay, sir. Sir, at that
Because
stage,
accused cannot be discharged unless we summon him.
yes.
It is dismissal of
Dismissal of
complaint under
complaint.
section 203. Let us see that under section 204, the judicial magistrate has summoned the accused. Then what is the position? Accused has appeared in the court.
Sir, if the accused has appeared, then again you will go with the examination of the complainant and the witnesses. If the court is satisfied that no case has been made out against the accused person,
Under which section he is examining, the judicial magistrate is examining the witnesses at this stage?
sir, it is section 145 CRPC. 144 or 1. It's 244. I do not read
Yes,
the latest
244.
section.
We have come to that one. It is 244. He is examining the witness under section 244. Then proceed further. We will.
Sir, if the case is not made up, prima facie there is no case against the accused person, then he will be discharged. But if a case is
He will
made,
be discharged under which section?
245.
Yes.
And if there is a case which is made out against the accused person, the magistrate will frame the charges, and if he is of the opinion that he can be proceeded under the procedure provided under this chapter, and he also has the power to give him the requisite punishment, you will proceed with the case. You will inquire the accused person whether there are any prosecution witnesses that he would want to cross-examine.
How you will explain the statement of accused under the provisions of CPC?
So whenever the statement of the accused person is recorded, there are two stages. One is during the investigation, which is under section 164. The other is under section 313 of CRPC, which is during the trial and which is a mandatory provision for the court to follow.
What is continuing guarantee?
Ma'am, a continuing guarantee is a guarantee which is given for a series of transactions. Example A and B, they have a continuous business of selling and purchase of certain goods. Now C, he at the request of A gives the guarantee to B that all the goods that will be purchased in this 1 year, I will guarantee you that up to a particular amount. So this is a continuing transaction for which the guarantee is given.
Yes, sir.
Can a sentence be suspended under any circumstances?
Yes, sir. There is a provision for the suspension of sentence and it can be done by the appellate court or even the court which has passed the sentence if it is satisfied that there is a period of limitation, that the period of limitation for appeal is pending and the person has a bona fide intention to prefer an appeal to the superior court.
Yes. Happy?
Can you explain the maximum pre-pending SC examination? I'll give you an hint. It is provided in Order 18, Rule 16, where the witnesses has to be examined immediately. Now you may continue.
Ma'am, de benis examination is basically where there is an apprehension that a witness whose examination is required for a particular suit, he is about to leave the jurisdiction of the court. Then even before the process of examination has started, then the court may, at its own instance or at the instance of the party, the witnesses, they can examine him before the proceeding with the suit itself.
Very good, Haram. You have given right replies. You are having full confidence. Maintain it. God bless you. And in this time, you must be selected. All right, all the best.